You've brought a car accident case, or maybe a wrongful death, or even a possible medical malpractice case, and now you're wondering if there's something damaging in your medical records, can you keep it out at trial? Would you like to learn the answer? Come join me as I share with you that information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. You know, there are some instances where you will be involved in an accident or be involved in some type of wrongdoing that causes you injury. And there might be something damaging in your medical records that you might not want to come out and have a jury see that. Is there a way for you to prevent the jury from seeing that damaging information? So let me give you an example. Let's say, for example, you go to a holiday party and you've had something to drink. You've had a couple of drinks, and now you're involved in a car accident. But the car accident wasn't your fault. It had nothing to do with you. You were stopped at a light, you got hit in the rear. But now when the ambulance comes to the scene, it turns out that you tell them that you've been drinking. Now you go to the emergency room, they draw your blood. Turns out you've got alcohol in your system. But does that have anything to do with the fact that you got hit in the rear while you were stopped at a red light? Well, obviously the answer is no. However, it may be difficult for you to keep out that information about the fact that you had been drinking, and here's why. You see, the law in New York requires that if your statements are relevant and related to the doctor's care and treatment of you for the purposes of diagnosing and treating exactly what's going on with you, then that information will likely come out at trial. However, if the information that you want to keep secret, that skeleton in your closet, had absolutely nothing to do with the doctor's diagnosis and treatment of your particular condition at that time, well, there's a good possibility that we can try and keep that information out legally, and that the jury will never hear that information. Now just think about the difference between a jury listening to your case, getting hit in the rear, and you suffering significant injuries, compared to if they hear the fact that you had been drinking that night, and now they strongly will suspect, and the defense will clearly argue, that somehow, some way, you should never have been driving and you should not have been on the road because of what you had been drinking that evening. So to answer the question, can you keep out damaging information? Well, if it's got nothing to do with the diagnosis and treatment of your particular condition that brought you there, then there's a good chance that you might be able to keep that information out. So why do I bring this up? I bring this up just to give you an idea and an insight into some of the things that occur during the course of a case involving an accident, a wrongful death, or even a medical malpractice case here in the state of New York. You know, chances are you have questions or concerns about your own particular legal matter, and if your matter happened in New York and you have legal questions, what I encourage you to do is pick up the phone and call me. I answer legal questions like yours every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.